First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case on the docket scheduled for oral argument this afternoon, the case of Tracy Wright versus State of Florida. You may approach counsel. Counsel allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. 5 minutes, please.
So noted. You may continue, counsel.
Thank you. Matthew McLean on behalf of the appellant Tracy Wright. This is an appeal from a juvenile sentence review proceeding pursuant to Rule 921.1402. We raised two issues on appeal. I'd like to go and start with the second one first. When we look at this case, Mr. Wright was convicted of felony murder, and there was no specific jury finding as to whether he actually killed, intended, or attempted to kill the victim. At the resentencing proceeding, after the juvenile resentencing laws were enacted.
So the first trial, he admitted to the crime. He admitted that.
Correct.
Yeah.
There's evidence that he admitted to the murder and actually being the killer.
Okay.
There's no actual finding, though.
So we had resentencing in front of Judge Hobbs.
We have resentencing in front of Judge Hobbs.
And then we had the 15-year hearing under Judge Wheeler.
Correct.
And at that, the defendant showed up and said, I didn't do it, right?
I think it was earlier than that. It was at the resentencing proceeding before Judge Hobbs that he said that he did not do that. We had a witness testify, Earl Moore, who said that his co-defendant, Wunbush, was the one responsible for killing the victim in the case. So at resentencing before Judge Hobbs, that's the evidence before the court.
So your theory is because Judge Hobbs set the review for a 15-year review that she implicitly held, because the order doesn't say anything at all about it, correct?
The order cites the statute in the subsection that provides for a sentence review after 15 years if you're not the actual killer in the case.
Okay. And so you think her citing that statute would have been 921-1402 2C was enough of a ruling that Judge Wheeler was bound by law of the case on that?
Yes, that's the statute is in place, and in the statute itself it says that this is reserved for those who did not actually kill, intend, or attempt to kill the victim in the case.
But there was not a finding of fact by Judge Hobbs to the extent that
There was
the
no
did not kill or intend to kill.
There was no factual findings. She did a resentencing where she pronounced the term of year sentence, which did not include the 40-year mandatory if he was the actual killer in the case. But there was no factual finding at the resentencing as to what she thought his participation in the offense was. But we do know the subsection.
Could have Judge Hobbs made such a ruling? Would it have been proper to say, I know you were tried some 13 years ago, but I'm going to find this fact that you did not kill or intend to kill as a matter of first impression? Could she do that?
I think she absolutely could do that, especially in light of the Williams decision, which requires there to be an actual finding by the jury to support whether they were the actual killer or not. So when you're looking at the case and it comes to the court as the jury rejecting premeditated murder, accepting a felony murder verdict, and you have a situation where there's no factual finding of an actual killing by Mr. Wright, then the court is required, pursuant to Williams and Aline and all that case line, that he has to be resentenced as if he is not the actual killer in the case. And that's what she did. And in furtherance of that, there was Mr. Moore, the co-defendant, who came to the resentencing proceeding and said that Mr. Wright is correct. He did not kill the victim. It was the co-defendant, Mr. Wunbush. So there was additional evidence in front of Judge Hobbs at that point in time to support the finding that Mr. Wright was not the actual killer in the case.
Am I right that whether he was the actual killer or not, when it comes to the review of sentence test that was applied by Judge Wheeler, that's really not the question? I mean, it might inform whether, looking at the statute, whether the juvenile offender was a relatively minor participant in the criminal offense, but it's not That's not the question.
It's not the question. It's whether they're a minor participant in the offense. But it's clear from Judge Wheeler's order that he found him to be the actual killer in the case.
And all three of the defendants, those who were involved in this crime, could be pretty major participants, it would seem, under the facts of what happened here.
Correct. But I think there's a big distinction between, and the statute makes a distinction between those juvenile offenders who actually kill, intend, or attempt to kill the victim and those who do not. There's legal significance to it, including the 40-year minimum mandatory that's required, which is not in Mr. Wright's sentence, and also the difference between a 15-year sentence review and a 25-year sentence review. And Mr. Wright was afforded a resentencing and a sentence review as though he was not the actual killer in the case. Yet Judge Wheeler treated him as though he was the actual killer, which is a significant due process violation. I think if you have a case today that came through the court system with the benefit of all these new laws, and you have a verdict that does not reflect that they're the actual killer in the case, then you can't go ahead and hold somebody as though they are. You have to be limited by the verdict in the case.
Well, this decision was also in the alternative, right? He says, finally, if the sentencing court necessarily found the defendant was not the actual killer, and this court is bound by that finding, this court still finds that based on the testimony and evidence that he was not a minor participant.
The court did say that, but throughout the order, it's clear that he's treating Mr. Wright as though he is the actual killer. And there's no alternative conclusion in saying if this was the situation where he was not the actual killer, where he was the actual killer.
Judge Wheeler said that even given if he was not the actual killer, I would sentence the same, right?
He never said that. He said that he would still find that he was not a minor participant in the offense. So there was never a sentence or a conclusion that I would deny the sentence review under this alternative theory. The statement he said was he still find him to be a major participant in the offense. But there has to be a distinction between someone being treated as the actual killer and not the actual killer in the case.
So in these sentence reviews, who has the burden of proof in these?
So the only real indication in the statute is upon demonstrated rehabilitation, then the court shall modify the sentence, or in the alternative if he does not demonstrate it. So I think it is.
So the defendant has some burden of coming forward with establishing that they've matured, that they're are ready for a lower sentence, that at some point in time they should get out of prison and rejoin life, right?
So the defendant has the obligation to initiate the proceeding, but I think ultimately the obligation in weighing the evidence, which would be submitted by both parties, Mr. Wright would go ahead and submit his evidence of rehabilitation. If the state wants to go ahead and contest that finding, then they would have a burden to go ahead and place evidence on the record as to why he's not rehabilitated. And then the court's tasked with, upon demonstrated rehabilitation or not, to modify the sentence.
Assume for the sake of argument that Judge Haas did make the finding that the appellant did not intend to kill the victim. Would Judge Wheeler have been bound by that finding?
Yes, I think so. I think the court can go ahead and talk about his participation, but when someone is convicted of a crime, you can't go ahead and say, well, I disagree with that verdict. I think he was the actual killer. I think it was premeditated when there's no verdict to go and support that. So when we look at the Shelko case, that's a situation where the defendant is charged with simple possession of a drug, and yet the court goes ahead and offers the opinion at sentencing, well, I think this is a cartel-style drug. I think that you're in the business of selling methamphetamine in that situation, and the Fifth District Court of Appeals said that's a due process violation. He wasn't convicted of that. He was convicted of just possession of the drug. So when we go ahead and enhance someone's sentence based off of an improper finding, that's a due process violation pursuant to the case law.
So you want to talk about your other argument?
Sure. I'll go ahead and move to the other argument. Basically what happened was the state went ahead and tried to introduce records that Mr. Wright had committed disciplinary report infractions while in the Department of Corrections. They didn't offer any sort of witness, no sort of business record authentication. They just submitted a document that has the Department of Corrections heading at the top, and it shows various disciplinary report infractions and facts regarding that obtained from witnesses.
So your argument is, and correct me if I'm wrong, but I thought from the briefs that your argument was that it was inadmissible hearsay, but you seem to be saying now that it was hearsay that might have been admissible, but the state didn't lay the proper foundation.
No, I was just trying to lay the setting before the court. I'm saying that the argument is that hearsay should not be admissible at this type of proceeding when it's pertinent to the factual findings that are required by the statute. So when we have a situation where the defendant disputes...
Well, in these cases, the defendant or the person who was convicted is going to come forward and say that, I've been in prison all this time and I've been a model prisoner and I'm ready for a lower sentence, or perhaps I'm ready to be freed now. And so the state, the evidence that they have contrary to that is going to be of the person's behavior while they were in prison. How do you think the state needs to prove that up?
Well,
do they have to have every corrections officer that saw a violation come down to prison, or or is there a way to get it in under a business records exception, or how do you see that working?
Well, I think that if the defendant disputes the uncharged conduct and it doesn't result in any sort of charge or convictions, and they're relying solely on statements by witnesses that's clearly hearsay, then they do need to offer some sort of corroborating evidence to substantiate the hearsay statements that are made in the report. Here we don't have anything, and these reports were in the past 2 years. This was a Gadsden County proceeding where he's incarcerated in North Florida. To go ahead and say that, well, this is a situation where this happened 30 years ago.
But, counsel, wouldn't you agree that these reports were relevant to the appellant's sentencing?
I think that it can be relevant, yes, to go ahead and show whether he's rehabilitated or not. But in a situation where a defendant has a right to go ahead and contest evidence and make the state present evidence that is substantiated by actual facts, he objects to it. It's proper for him to go ahead and do so, and the state has to come back with some sort of corroborating evidence instead of just handing a piece of document saying that he did all these bad things when there's no actual evidence that he did those bad things.
Judge would have relied on the Fourth District's opinion in McHenry versus State in support of his decision. Can you distinguish McHenry, or does it apply to the facts of this case?
So in the Fourth District decision, the biggest distinction I can make is that in a judicial sentence review, if the court is not going to modify the sentence, they're required to make certain findings. In the Fourth District decision, it's a sentencing proceeding where a court is not required to make factual findings to support its decision. So when we have a situation like the Fourth DCA decision, where there are no required factual findings, then hearsay has been held admissible. There's other proceedings where courts have considered whether hearsay is admissible at sentencing proceedings. There seems to be a distinction of in enhanced sentencing proceedings, the state has to go ahead and introduce non-hearsay evidence. And then there's situations where a defendant, in requesting a downward departure sentence, has to go ahead and present non-hearsay evidence. So we believe that this situation where there are required findings, such as in enhanced penalty situations and moving for downward departure sentences, that factual findings are necessary, and therefore these findings have to be based off non-hearsay evidence. So that's the best distinction I have between this situation and the Fourth DCA decision. When we look at this court's case law in Smelly, that's a situation where the defendant disputed prior convictions being used to be scored in a score sheet, and this court said, no, if you don't have non-hearsay evidence, then it should not be counted in the score sheet. So this court's own precedent says in sentencing proceedings, when there's factual findings necessary, it needs to be non-hearsay. And the state didn't do anything to go ahead and present
Mr.
non-hearsay
McClain,
evidence.
you're well into your rebuttal time now.
I understand, and I'll
Okay.
reserve the remainder. Thank you.
May it please the court, Virginia Harris on behalf of the state of Florida. I'd like to start out by saying that appellant has waived an Elaney claim. He did not raise that in the initial brief. He seems to, in the reply brief and also here at oral argument, suggesting that there was an Elaine violation, and he didn't argue that, so we consider it waived. He argued that Judge Wheeler was bound by Judge Hobbs' prior determination that he was not the killer, which alleged determination. And so that is not an Elaine violation. And an Elaine violation is when
But the original conviction was under a felony murder theory, correct?
Correct, but he
And there was never any finding that this defendant killed or intended to kill anybody, correct?
That is what appellant has said in the record. I did not see where the trial was included on appeal, and I did notice that appellant had some attachments to his memorandum of law for the resentencing that are in the record, but I looked on your website and they're redacted. So it's possible that he included those and that it's just redacted, but I can't view them. I did notice that the parties did not contradict Mr. McLean when he said that the jury did not make findings, but on appeal, he has not argued that Judge Wheeler could not find him to be the killer because the jury didn't find that he was the killer. I've looked at his issue multiple times, and I look at it at the time that I filed the brief because I was going to do a motion to ask for the record to be unredacted. But when I saw that he wasn't arguing that, then I didn't. So our position is that it's waived, but in any event, I'll address it anyway. It's not because an Elaine violation is when the sentencing judge makes a finding of fact that the jury was supposed to make that enhances the penalty. In a judicial review, the judge is not enhancing the penalty. He's just not agreeing to let the defendant out. That's not the same thing. And also, in this case, the defendant admitted at trial that he killed the victim. It looks to me from looking at the record and the cross-examination of Dr. Butler, who was his expert at the resentencing, that he suggested it was an accident after the victim made sexual advances toward him. But he admitted to that. Then, at the resentencing, he presented a theory of defense that Winbush killed the victim and that he was just taking the blame. Then at the judicial review, he says that Moore, the other co-defendant, is actually the one who killed the victim. So he's changed his, theory of defense. And the judge at this sentencing heard live testimony from the defendant and heard a different theory of defense than was presented by Judge Hobbs. Pursuant to the Florida Supreme Court's case in Davis and also Carl Lewis Burns, the judge is allowed to consider the evidence presented at trial, and he's also allowed to consider his freely offered statements made at sentencing. And the judge was allowed to consider that he confessed to doing it at trial. He observed him admit that he confessed at trial and say that it wasn't true, and he's allowed to assess his credibility, which he did, and he didn't believe him. He found him insincere and went on in his order about the different versions of events that were provided by the defense. So at trial, the defendant said there wasn't going to be a robbery. And it's the first theory I told you about the victim came on to him, and then he killed him, like in a chokehold. He suggests he didn't mean to do it. Then he has his brother, Moore, who's a co-defendant, and this would be Earl Moore. And Earl Moore comes in, and he says there was going to be a robbery, that it was their idea, which would be referring to the defendant and Winbush. And he says Winbush killed the victim and that the defendant didn't do anything. He didn't even involve himself in the cover-up, which contradicts his trial testimony, and that it wasn't his idea. Then at the judicial review, the defendant presents Winbush, who then says Moore is the one who killed the victim, and the defendant says that as well. So he's changed his story numerous times. And the state tried to cross-examine Winbush, didn't you say, because Winbush and Moore both testified against the defendant at trial. Moore was jointly tried with him, and Winbush testified as a state witness, and they both said that the defendant killed the victim. And so the change in what happened is almost insulting. And if you look at the trial judge's order, it's clear that he didn't find any of this credible whatsoever. So he heard from the defendant himself, and he also heard new testimony that Judge Hobbs did not hear. I do not believe, as the trial judge indicated, that Judge Hobbs made a finding that he was not the killer. If you look at the record, and the trial judge includes that in his order,
But she's setting for 15-year review, so wouldn't she have to make that finding too?
Well, let me
that
explain what happened. So the resentencing was held at the beginning of February in 2019, but she didn't sentence him right then. She didn't sentence him for a couple of more months. I believe it was the beginning of April of the same year. If you look at that hearing, no one reminds Judge Hobbs, this statute means this statute. There's no discussion of that whatsoever. Like the trial court indicated in its order, it looks like she imposed the judicial review based on how much time the defendant had served. She actually asked, so how much time did he have in? And Mr. McLean said, I think he said 14 years or something like that. And she goes, well, we'll go with the 15-year judicial review. It really does look like she believed she could impose that based on how much time he'd served. But in any event, she, if she hadn't said that, there was case law at the time, Williams, that came out in 2018, which indicated that the state could not impanel a jury to make this finding if there was an Elaney violation. So she might have felt that she had to impose that review because there wasn't a finding, and it doesn't mean that she found the defendant credible. I think the record shows that she did it based on the time served, as the trial court indicated, but that is also an issue to consider. But even if she had made a finding, the Judge Wheeler was not bound by that. The jury did not acquit him. There wasn't a bench trial where Judge Hobbs heard the evidence at trial and acquitted him. He wasn't acquitted. This judge heard new evidence and heard live testimony from the defendant himself, and he was permitted to assess that evidence and make his own independent determination. And as he noted in his order, if successor judges were bound by the findings of the initial judge, then what would really be the point of them having this hearing to begin with? And in truth, most of the time, it would probably be more harmful to the defendant if the judicial review judge was bound by findings of the initial sentencing or resentencing judge. So he was not bound. And then, as I think some of you mentioned already, any error would be harmless. The judge made it very clear in his order that even if I'm not allowed to do this, I'm still weighing this factor against him, that this was his independent decision. He was involved in the cover-up. He made it very clear in his order that he would have weighed that factor against him. And when you look at the entire order, the entire order is just scathing toward the defendant. There's not a single factor. Sometimes you see with the resentencings where the judges will say, this factor favors the defendant, this factor doesn't, but overall I'm going to do this. There is nothing in this judge's order that favors the defendant. The fact that he found him lacking in credibility about his remorse, I mean, that's especially damning. And that kind of, so any error would be harmless.
Okay, so what about the disciplinary reports?
Well, appellant initially objected based on sentencing case law and suggested even in the trial court and now on appeal that because he was contesting it, we had to provide corroborating evidence. Well, the case law says that the state has to do that when they're seeking an enhanced sentence. We're not seeking an enhanced sentence, so that's why he has all this case law in his brief about HFO and stuff like that, where we're seeking an enhanced sentence, but we're not. In fact, we're just opposing his request to modify or mitigate his sentence. We're not seeking an enhanced sentence at all. So generally, hearsay is admissible in non-capital sentencing proceedings unless the state is seeking.
Is that McInerney?
It's one of the cases,
Okay.
yes. And so And then on top of that, I had argued that even if you thought it was error, the defendant opened the door to this. When initially the defendant, when he was testifying, he was talking about the later programs that he got into, wastewater management, and I think the Horizon program. And he indicates that you have to be clean of DRs to get into this program. So that is suggesting to the judge that, he's been behaving in prison, which is not accurate. And so it's our position, pursuant to Tipsy Coachman, that the state would have also been able to present those to rebut that that's not actually true. I think the state argued he got 6 DRs in a 2-year period. And so I think we should have been able to rebut that. Opening the door allows even otherwise inadmissible evidence to come in. And appellant has not disputed that I'm incorrect on that. All he says is that I am not allowed to argue that because it's not preserved below, but I'm the appellee, and we don't have to preserve our arguments. So we would be relying on Tipsy Coachman for that. And then finally, I did also make a harmless error argument. I agree that the judge did rely on the disciplinary reports for finding that he was not rehabilitated. I acknowledge that. It's just in this particular circumstance, his order is so bad. I mean, when the judge says, I don't believe you that you're not the actual killer, I don't believe you that you have remorse, I don't believe the witnesses that you've presented. Also, he was also serving a sexual battery charge, 25 years. Mr. McLean's sentencing memoranda for the resentencing, the second one, indicates that the defendant and 2 other co-defendants, I don't know if they got prosecuted though, raped a 6-year-old anally and bound him by his arms and wrists. The defendant's brother, Alexander, testified, and despite the fact that they both came from a tough background, his brother, Alexander, turned out great and is highly educated and has a good job and is doing well. So the judge, didn't give him the benefit of that. The defendant, like you said, even if he wasn't the actual killer, he was a major part of this. They put the body in the trunk, leading the victim's daughter to find him there, and use credit cards of the victim, or tried to use credit cards of the victim later. So it's very obvious there's nothing favorable about the defendant and the judge's order. So it's our position that he would have not released him even if the DRs had not been admitted. Are there any other questions? We ask that you affirm.
Thank you, counsel. You may approach, counsel.
May it please the court. First off, I'm not alleging a lien violation here. What I'm saying is that when someone is sentenced as a non-killer, it's improper for a subsequent judge to then say, I'm going to find that you are the killer in the case. That's what I'm saying. And I'm saying that Judge Hobbs made the correct decision at the time based off of Williams and other decisions. The state has put forward all this negative talk about Mr. Wright. And the reason why it's so negative is because they found him to be the actual killer, and they found all these DRs. That was the thrust of the entire court's order, and we're saying that both of those were improper for the court to go and consider based off of him being given a sentence review as the non-killer, and then the state not introducing non-hearsay evidence. We're asking the court to reverse and remand for a new sentence review for a different judge. Thank you.
And thank you, counsels, for your respectful oral arguments. This concludes our oral arguments for this afternoon. We are adjourned.
All right.
Nice to meet you. What's that? I said, nice to meet you.
Yeah, nice to meet you.
And have a good drive back.
Yeah.
What is it, like 4.5 hours?
Yeah, it was 3:45, so hopefully no traffic again.
Yeah, I guess it depends on what the Orlando. Is it bad going to Orlando from here, though?
Well, I kind of live on the outskirts of Orlando, so I don't have to go through downtown.
There you go.
And we also, they put in some express lanes through downtown Orlando, which is also like a pretty big time saver as well.
Y'all. Yep. Good job, guys.